Okay. Good afternoon, ladies and gentlemen. We're here in the Franklin Circuit Court for arguments today in the case of Anthem Kentucky Managed Care versus the Finance and Administration Cabinet and the related claims that have been consolidated into that case. And we've got a lot of ground to cover and a lot of issues to discuss. So I think we probably should just move right into the arguments. And I've been trying to think what the most efficient way to do this is. So I'm not completely sure, but I think probably let's just, I'm going to start with each in turn, each party that has filed a motion for judgment, summary judgment, or partial summary judgment, and then open the floor, and I'll let everybody who cares to respond to each motion do so, but hopefully we'll try to be efficient and consolidate some of these responses with perhaps the cross motions that have been filed. So we'll just get started then, and I will say I'm going to ask everybody to try to be somewhat careful and respectful of the time allotted here. I want to take as much time as necessary, but I do have some limitations on my time, and I'm hoping we can wrap this up today, shortly after 3 o'clock. And if we need to come back, we'll come back, but I'm hopeful we can cover the primary arguments that need to be made here over the next hour and a half or so. So with that said, I'm going to recognize counsel for Anthem to present their arguments first. And Mr. Washburn, will you be speaking for Anthem?
I will, Your Honor. Thank you.
Okay.
Thank you for the time and for indicating we've got 90 minutes. As you know, as the court is aware, we moved on 4 issues. We moved for judgment on our own claims, specifically with respect to Molina and seeking Molina's disqualification. Second, our contentions that the scoring process was contrary to law and otherwise arbitrary and capricious. Then we also moved with respect, we moved to judgment on United's claim that Anthem should be disqualified. And we've also moved on United's claim that CHFS should be limited to 5 MCO contracts based on the language of the RFP. And so I've got argument with respect to each of those. I'm going to start with the Molina piece, which addresses not only our motion, but Molina's cross motion for judgment.
Okay.
Okay. Sure. There are, and I have 6 substantive points to make with respect to Molina, and specifically Anthem's contention that Molina's violations associated with engaging Emily Parento in violation of the Executive Branch Code of Ethics requires its disqualification. The first point is that Molina's suggestion that transition team members cannot be subject to the Executive Branch Code of Ethics as a matter of law is illegitimate. The argument that a transition team member, well, it's an idea, frankly, that's absurd in general and not supported as to the specifics of Molina's argument. Generally, the suggestion that a person can interact on questions of policy with the incoming governor and his appointees on specific issues, gaining an enhanced understanding of the incoming administration's views and preferences, and then engage with private industry on the precise subject that she advised on, while not being subject to any ethical limitation, is contrary to the letter and the spirit of the Code of Ethics. This is precisely the kind of situation that the Code of Ethics was designed to prevent. Moreover, the code's language does not support Molina's argument. It's based on the assertion that it's limited to, quote, personnel, which is not defined in the Code of Ethics. But Molina contends that personnel must mean, quote, employees, even though personnel is not limited to employees in any of the definitions that Molina cites. Molina also cites to Chapter 18A of the revised statutes, which is a relates to merit.
Personnel statute, yeah.
Right. But that doesn't, again, doesn't really affect the ethics code at all. Similarly, the suggestion that the governor-elect's team is not the executive branch is too cute by half. All of the officials that Parenteau was engaged with were heading into positions of power in the Commonwealth government within days of her confidential meetings with them, including the incoming secretary of CHFS, the governor's chief of staff, and the governor himself. The exceedingly narrow boundaries that Molina seeks to place on these definitions, which are not supported by the language of the ethics code or otherwise in the statutes, would countermand the entire purpose of the code. That, though, leads into my second point with respect to this, which is, in any event, whether or not the code of ethics applies to all transition team members, it plainly applies to Emily Parenteau because she expressly agreed to be governed by the code of ethics in exchange for gaining access to confidential information to which she otherwise would not have been entitled. Molina has raised two arguments that actually support Anthem's contention and the conclusion that the code of ethics applies to her. First, Molina cites what I'm going to refer to as EBEC Advisory Opinion 0350, but that opinion supports Anthem's position. The opinion is written for the protection of rank and file employees who might be asked by transition team members to disclose confidential information and are concerned about the risks associated with that disclosure, including statutory penalties that they may be subject to, but also concerned about the risks associated with refusing to answer questions asked by representatives of the new administration. The advisory opinion explains why, when Ms. Parenteau asked CHFS employees and officers for confidential information about the Medicaid MCO RFP, she was asked to play by the same rules as the employees and sign a commitment that the ethics code would apply to her as it applied to them. Second, Molina contends that no consideration was provided in exchange for her agreement to be subject to the code of ethics. Under Kentucky law, mutual promises constitute adequate consideration if a benefit is conferred to the promisor or a detriment is incurred by the promisee. And that's from Energy Homes versus P, Kentucky Supreme Court 2013, but it's Hornbook law in Kentucky and elsewhere. There's no question that Ms. Parenteau received a benefit. She received access to confidential information, and the Commonwealth incurred a detriment, the obligation to provide confidential information. That did not exist before that NDA was signed. After signing the NDA, Ms. Parenteau effectively received a golden ticket. She was able to talk to whomever she chose about the Medicaid MCO procurement. She was able to review any document she chose, including the entire procurement file.
Yes, as I understand it, Molina argues, though, that although she may have had access to the whole panoply of filings and so forth, that really the only information that was disclosed to her or that she requested was the identity of the successful bidders. Is that what she testified to?
That is what she testified to, Your Honor. As to the question of consideration, however, which is what Molina is contending, she gained access to information.
Right, she got a benefit from signing that.
That's exactly right, Your Honor. And so therefore, Molina's reference to the Creech versus Brown case, in which an employee was asked to sign a non-compete, but didn't get anything in return. He was an existing employee, didn't get any additional benefit, but was subject to additional detriments. That was not sufficient consideration.
Yeah. I will say, with regard to Ms. Parenteau, and you all can address this, the others can as well, but my primary concern with Ms. Parenteau's role is not that so much that she got insider information or that gave Molina an unfair advantage. My concern is the appearance of having someone who, had political connections and was chair of the transition team, then turn around and serve a role for a bidder in a public procurement. That to me, that the concerns that raises is more a question of the appearance, which I think is very important. But that's where my primary concern is. I don't think there's much evidence, or nor am I that concerned about insider information being disclosed that gave Molina an advantage. My bigger concern is with the appearance of political influence in the process. And, frankly, that also goes to the question of, how these bids were scored. When a scoring team from state government is expected to score proposals where one of the bidders is a political insider who's got close ties to the governor, that puts the scoring team in a awkward position. That's another one of my concerns. So those are my primary concerns with regard to the Parento involvement in Chapter 11A.
Well, Your Honor, appreciating those comments and also mindful of your effort to move this along as efficiently as possible. I would just note then my headlines for the next couple of points and would be happy to answer further questions about them.
Sure.
But Molina has argued that the contract was ambiguous as to its application as Parento. With respect, the document is clear and unambiguous that the Code of Ethics applies to her. Similarly, Molina has argued that the Ethics Code would not prevent her from working on the 2020 RFP because she was discussing the 2019 RFP. With respect, that's the same matter. There wouldn't be a 2020 RFP, but for her discussions with the governor with respect to canceling the 2019 RFP, those are the same. So I'll skip ahead unless the court has further questions with respect.
No, go ahead. Yeah.
And say that the Ethics Code, in this case, the violation triggers disqualification. Molina affirmed under oath in submitting its bid that it had not knowingly violated the Code of Ethics, but Molina's engagement of Parento to assist with its response was directly contrary to that attestation. The terms of the Code of Ethics were incorporated into the RFP and the Medicaid MCO contract, and Molina violated those terms through its submission. As reflected in its inclusion in the RFP, the Code of Ethics and the Model Procurement Code fit hand in glove to ensure that procurements are handled ethically and appropriately. Molina's suggestion that a plain violation of the Code of Ethics and the restrictions on employment should not trigger disqualification invites the court to perform a complicated act of dentistry, that is, to pull all of the teeth from the Code of Ethics. Molina's arguments do not justify such a result. Molina points to provisions of the Model Procurement Code 45A 340, which applies to current officers or employees of the General Assembly or agencies, and 45A 455, which relates to certain conduct by current or former public employees. However, neither statute states that they provide the exclusive restrictions on conduct related to procurement. And certainly they do not, as Molina argues, permit Ms. Parento to act as she did. Disqualification is contemplated, in fact, required by the Code of Ethics. Molina points to 11A, or to a portion of 11A 100 paren 4, which provides that any violation of this chapter which has substantially influenced the action taken by any state agency is a ground for rescinding or canceling the action. Again, and so Molina says, well, there's no proof of substantial influence, and therefore there's no justification for rescission or cancellation in this case. Again, that clause is not exclusive. Indeed, that provision itself contemplates the other remedies provided by law and does not restrict this court's authority under the Model Procurement Code or the Code of Ethics. The court obviously has the power in its review of agency decisions under KRS 13B 150 to invalidate an agency decision, including a contract award by the FAC. The suggestion that the court's authority is limited is just not supported by Kentucky law. I'll note that I recently reviewed a federal case I did not cite in the brief, but I did want to note this quote: "A procurement system powerless to rid itself of an unfair competitive advantage gained through inside information would soon lose every vestige of competitiveness. There can be no question, therefore, that the contracting officer had an authority to act and in an appropriate case to cause the disqualification of a bidder." The court certainly has that authority. That, by the way, is the NKF engineering case, 805 F. 2nd, 372. It's from the Federal Circuit, 1986. Your Honor referred to the fact that Ms. Parento's engagement by Molina was noted, expressly noted by the scoring team. They asked questions in the documents about what Ms. Parento's role would be with Molina going forward, providing clear indication that they were concerned about it in precisely the ways that the court has expressed today. Moreover, and while the court has indicated that it is concerned about an appearance of impropriety, there are certainly facts here to establish that she not only violated the code of ethics that prevents her from being employed for a year, and in fact, it's that cooling off period that is the code's attempt to resolve the appearance of impropriety issue that the court expresses its concern about. And that clear violation of the code, in addition to Ms. Parento's disclosure of confidential information to Molina as it prepared its bid, creates a clear distinction between this situation and the cases that Molina has cited. Finally, even under the standard that Molina would travel under 11A 100(4), Ms. Parento actually used the information she gained for Molina's benefit to substantially influence the FAC and the scoring team's decision. I noted the scoring team made reference to her participation. And as the court previously noted, they received the message sent by Molina that it had an insider with contacts and influence with the administration guiding its proposal. We've discussed on several occasions, both in briefs and in previous arguments, to your honor, the substantial evidence of Ms. Parento making extensive comments and revisions to Molina's submission to specifically tailor the bid to be consistent with her immediately prior work on the transition team. And I'll skip over those parts again in the interest of moving forward. They're all in our briefs.
Yeah.
Molina suggested all of this information was available to the public and to healthcare experts who have an understanding of how progressive administrations think. This argument is based on the idea that Molina, which is itself a sophisticated and successful healthcare company that has operated for years in numerous states with progressive governors and administrations, had no idea how to communicate these concepts until Ms. Parento came in. That's not what Molina was asking for. Molina paid an exorbitant price to retain Ms. Parento, and it knew what it was buying. It was buying the access to somebody with inside information and expertise about how this particular administration would think and view its proposal, and associating with her in order to advance its own cause with respect to this procurement. Molina has obviously submitted a number of affidavits in response to Anthem's motion. However, there's no dispute of material fact on the essential questions. Ms. Parento committed herself to the Code of Ethics for the purpose of gaining access to confidential information. She participated in a confidential process and gathered confidential information. Then she promptly violated the Code of Ethics by going to work for Molina. While working there, she relied on information she gained through the transition team work to advance Molina's bid. All of these facts are established and indisputable, and they support judgment in Anthem's favor. Molina's motion, on the other hand, cannot be granted. Anthem has not had the opportunity yet to gain any discovery from Molina, including any emails or internal communications from Molina employees about their retention of Ms. Parento, for example. And if the court is not inclined to grant Anthem's motion, on the Molina issues, it must deny Molina's motion and permit further discovery. So that's what I have to say with respect to Molina. The second point is with respect to the process, the procurement process, and three specific points with respect to the process. First, the oral presentations. Second, the decision to award full points to all participants without effectively scoring two categories of the procurement. And third, the scoring team's decision to deduct 10 points from Anthem's proposal for failure to submit its certificate of authority, when in fact Anthem did submit its certificate of authority in its hard copy submission. With respect, Your Honor, these issues were briefed and argued during the temporary injunction proceeding, and there are frankly, no new arguments or facts that have been submitted in the interim.
Yeah.
And so what Anthem would submit is that the court's October 23 order addressing those issues should be entered as final judgment on those points. And again, happy to answer any further questions or respond to other arguments, but not sure that we need to go over that ground again.
Okay.
Go ahead.
No.
All right.
Anything else from Anthem?
Two other points, Your Honor. And again, I'll be as brief as I can. The next point is with respect to United's claim that Anthem should be disqualified based on its employment of Catherine Easley in 2019. To recall, Ms. Easley was a former CHFS employee whom Anthem employed for 6 months in 2019. She worked at CHFS on 1115 waiver issues and marketing points for that. Again, those issues have been considered by the court with respect to United's motion to modify the injunction, and the court denied that motion. We would ask that the court's order with respect to that be applied here. The one note that I will make with respect to that point that it was not raised in that round of briefing is that CHFS responded to United's discovery requests. Court will recall that it permitted United to send certain discovery requests to CHFS about Ms. Easley and her employment there. And in response to United's interrogatories, CHFS made it abundantly clear that Ms. Easley had no role with respect to the 2019 RFP, contrary to United's allegations. What CHFS said is that Ms. Easley did not plan, create, write, draft, or edit any part of the 2019 RFP, consistent with Ms. Easley's representations to Ms. Gabhart, which led her to authorize Ms. Easley to work for Anthem. So again, just sort of confirmation that there's really no issue there.
Right. And as I recall, Ms. Easley had left Anthem, I think, by the time of the 2020 submission.
That's correct, Your Honor. Ms. Easley left Anthem in October 2019, months before the 2020 RFP was issued or before Anthem's response was due.
Okay.
Last point, Your Honor, and I know a number of parties are going to address this, so I'll be brief. United has argued that the language of the RFP saying the Commonwealth would select up to 5 MCOs prevents CHFS from contracting with 6 MCOs, as was ordered by the court on October 23. Under the circumstances, Anthem submits that the court should reject United's argument, also advanced by Humana, that CHFS is limited by the RFP language. And these arguments are addressed in the brief. So again, I'll just summarize very quickly. The master agreement needs to be read in a manner that prioritizes the public interest as reflected in the Model Procurement Code. Given these circumstances surrounding the RFP in this contract, the court should consider not only the RFP language, but the language of the statutes and the primacy of the public interest at stake to reject United's argument that CHFS is somehow limited. And with that, Your Honor, and again, mindful of the time, I will pause to allow others to have their say.
All right. Thank you, Mr. Washburn. I guess in light of the nature of the issues we've got here and some of the overlapping arguments, I'm going to recognize, I think, Molina to go next. So I'm not sure, Mr. Kramer or Mr. Denham, who's going to speak for.
Your Honor, I'm going to carry the oar primarily here.
Okay.
Depending on your questions, I may defer to my co-counsel, Mr. Caldwell of Caldwell Hammer, who
Okay.
represented Emily Parento and produced her for her deposition. But
Yeah.
thank you, Your Honor, for your time this afternoon. And a lot of issues briefed, a lot on your plate here, but we're going to try to reduce this to two issues, two major rulings that we're asking the court to make. First, Your Honor, we submit the facts and the law both strongly support Molina's continued participation in the Medicaid program and its service to more than 300,000 enrollees, including those who were previously served by Passport. There are the two primary rulings that we're asking for, Your Honor. They're based on undisputed material facts now before the court. First, the Commonwealth correctly determined that Molina's membership was not subject to reassignment to other MCOs based both on the plain language of the contract and in the interest of continuity of care, which no one disputes is in the best interest of Medicaid enrollees. And second, Your Honor, we ask you to rule as a matter of law that Molina's contract is not subject to cancellation, because contrary to what you just heard from Mr. Washburn, there is absolutely no evidence of any unfair prejudice or improper influence in the procurement process that could overcome the statutory presumption of correctness. On this point, Anthem has totally failed to meet its burden of demonstrating that the Finance Cabinet acted in a manner that was arbitrary and capricious or contrary to law. Let me turn to the first issue, if I may, Your Honor, and that is that our membership was not subject to reassignment to other MCOs. There's three main points here. First, Your Honor, the Commonwealth got it right when it determined that Medicaid enrollees who had been served by Molina since September of last year due to the assignment from Passport should not be reassigned effective January 1. Molina was certainly, quote, currently contracting, unquote. That's the operative language.
Is September the date of the approval of the acquisition of Passport by Molina?
I believe it was closed in September, yes, Your Honor.
Yeah. Mm-hmm.
So currently contracting, section 26.2 of the contract states that such an MCO that is currently contracting shall not have its current membership reassigned. And Your Honor, we've addressed this extensively in our brief, but it only makes sense that currently and current membership in that section refer to the situation at the date of the allocation at issue, at the time action is to be taken. As we showed in the brief, any other construction will lead to absurd results. And I'll just briefly mention a couple of those. First, if you read current membership in 26.2 to refer to May of 2020 when Humana suggested when their contract was signed. It makes no sense because an MCO's membership is static, is not static. It fluctuates through the year. People are added, people drop off. So in cases where members were added between the signing of the contracts in May and the assignment decision date in December, under Humana's reading, anyone they picked up between May and November would have to be reassigned in December. That makes no sense. It would needlessly disrupt the care of all Kentucky enrollees who joined Medicaid between May and December, including probably many thousands of people who suffered because of the COVID pandemic. Mm-hmm. Avoiding that kind of disruption, Your Honor, to continuity of care is exactly what the currently contracting provision was intended to do. And I think your prior ruling on the injunction recognized that.
Let me ask you on this point, it's I guess the concern I've got, and I'll let you address it, is that it does seem to me like there is a legitimate question here about whether Passport could assign its membership or to Molina for the contract period that didn't commence until afterwards, so in other words, Molina couldn't assign or couldn't be assigned by Passport a right that Passport didn't have in the first place. And, it does appear on the record to me anyway, that Passport really didn't have any membership for the relevant year, or for the relevant time period that it could assign because it was not a successful bidder.
Your Honor, there was an asset purchase agreement. There was an assignment by Passport to Molina that was approved at multiple administrative regulatory levels, both state and federal. It turned Molina into a currently contracting MCO. And the date of the decision on who keeps their members was in December of 2020, and Molina was currently contracting. It only made sense to construe that as of the time of the assignment. Your Honor, the slides that we submitted shortly before the
acquisition was in September, and the allocation was made in December. So your all's position is that you all were already currently serving all of those Passport members.
Yes, Your Honor. And the entire purpose of that currently contracting provision was to promote continuity of members who were with a plan at the time of assignment after open enrollment had closed and they had not selected another plan.
Yeah.
Your Honor, slide 4 that we distributed, if I could just briefly refer to that. I don't know if you received those. We emailed them before the hearing, but there's multiple uses of current and currently in the contract that can only be interpreted as meaning at the time of the action to be taken or the service to be provided. And clearly that's what currently contracting was intended to provide as well in the interest of continuity of care. Your Honor, I would also point out that the Commonwealth and United have already.
Let me ask you, how many members, Mr. Kramer, how many Passport patients are we talking about here?
A little over 320,000, Your Honor, as of the new numbers this morning. And we submitted to you affidavits of a care manager and of a physician who explained the disruption, the delay in care that can occur to these medical, many of them are medically vulnerable people. From a disruption in their.
I assume those are all primarily, or if not all, they're primarily in Jefferson County. Is that right?
I think about half the members.
Half.
Or less.
Well, Passport's area was Jefferson and I guess 7 or 8 surrounding counties, right?
Primarily, I think that's correct.
Okay.
So, Your Honor, in addition to currently contracting being construed in a manner consistent across all the contracts, the Commonwealth has appropriately emphasized continuity of care for enrollees as provided in section 26.2, which says the continuity will be a factor to the extent possible. The interpretation that's urged by Humana and others, frankly, would prioritize the interest of MCOs in gaining members over continuity of care for members who have an established relationship with an MCO like Molina and established relationships with providers in those plans. Your Honor, I would also note that the contract was designed to give the cabinet quite a bit of flexibility in administering the program and in promoting continuity of care. If you look at section 2210, it provides the Commonwealth does not guarantee any specific number of enrollees to any participating MCO, nor how long any members might be assigned to that MCO would remain with the MCO. And section 26.5.
What section are you citing there?
That is
26.5.
22.10 says it does not guarantee any specific number or how long a member will be assigned. 26.5, the cabinet expressly reserved the right to change the algorithm on assignment at any time for any reason. So there was a great deal of discretion retained by the cabinet in order to promote continuity of care. To the point that Anthem raised, that Mr. Washburn raised about Molina should have known that Ms. Parento was subject to the ethics code. First of all, we dispute that initial point. But secondly, we've submitted evidence they did not know. They were not aware of it. And the pertinent provision of the RFP, that's section 60A.6.A, point III, small Roman numerals, requires that the respondent must have knowingly violated a provision of the ethics code. There's no basis to convert that to what Anthem would apparently claim it should be a negligence standard. Melina did not know she was subject to the code, so there cannot be a finding that knowingly violated the code by retaining her as a contractor. So, Your Honor, we respectfully assert that the Commonwealth's decision-making has complied with the contract in a manner that best serves the interest of Medicaid enrollees, which is the entire purpose of the contract. So that'll take us to our second point, Your Honor, and that is why Melina's contract is not subject to cancellation. There's no evidence of any unfair prejudice or any improper influence in the procurement process. Mr. Washburn said Anthem's not been able to take any discovery. They've actually been the only party to take discovery. They took 3 depositions. Over 2,000 pages of documents were produced to them, including one I'm going to mention here shortly that totally blows a hole in their whole theory about Ms. Parento allegedly misusing confidential information she got from the transition team. But, Your Honor, the standards here under the ethics code, there has to be a proven violation that substantially influenced the procurement. That did not happen. Under the procurement code, there has to be a showing the cabinet's decision was arbitrary and capricious or contrary to law. That didn't happen either. And I know, Your Honor, we're asking you at this point to re-examine this issue because the more complete record now before the court shows that the preliminary findings that were urged on you primarily by Anthem are just not supported by the evidence. I apologize, I've got a siren going by here. We've devoted a lot of attention to this in our brief, Your Honor, but for today's purposes, I can boil this down to 3 primary points. First, there's absolutely no evidence to support Anthem's claim that Ms. Parento improperly accessed confidential information or fed it to Melina to give it an unfair competitive advantage. Also, no evidence that her role caused prejudice or created any improper influence on the process. The depositions they took included Stephanie Bates, who basically ran the scoring of the bid. She said it had no influence whatsoever. That's the only testimony. She was specifically asked, did it have any influence? She said no, it was just noted that her name was submitted. And Judge, Ms. Parento was recruited in the first place because in the scoring of the 2019 procurement, some comments were made that Melina's bid should be more Kentucky-centric. So they put out some feelers for the 2020 bid and were referred to Ms. Parento, who is clearly has great experience and expertise in Kentucky health policy.
Yeah, Kentucky experience.
Exactly. And, the main example that Anthem cited of this allegedly improper conduct and access to confidential information is claim that she replicated in their language, copied or cut and pasted language from the transition team report for inclusion in Melina's bid. We've submitted 2 slides on that today, Your Honor, and I'm not going to screen share them again because they would probably be illegible. But and also one of them includes some information that was designated as confidential in the agreed protective order by the cabinet. If you look at slide 2, that shows the transition team excerpt that Anthem claim was replicated in the material that Ms. Parento redlined into as a recommendation into Melina's bid, which is shown on the right side of that slide 2. If you go to slide 3, Judge, this supposedly replicated language on the left side is Melina's final response to the RFP. On the right side, this language that supposedly was lifted by Ms. Parento from the transition team was actually supplied by her or to her by an internal employee at Melina that they'd already prepared. So it's just made up, Judge. There's no base whatsoever to it. Their fallback when we called them on this.
Again, I would say on the Emily Parento issue, I would reiterate, my concern is not so much that she gained confidential information or used it to the advantage of Melina. My bigger concern is the appearance of insider influence and the effect that may have had on the process. And you know, that's kind of a subjective judgment. I'm you know, which is why I'm undecided about how the best way to handle it is, you know, in the context of this legal decision, because, you know, again, I do have a concern that, you know, when a bidder in a public procurement under the model procurement code is able to, you know, to hire the person who was head of the transition team to be their point person, you know, that creates an appearance of insider influence, which I think is at odds with the purpose of the model procurement code. And again, I think it does. I understand that the person who, you know, ran the scoring committee it may have said it had no influence, and you know, that doesn't surprise me. But there, you know, it's kind of hard to you know, to take that appearance out of the mix when you have a scoring team made up of state government employees who are working for the new boss, and one of the bidders has got you know, such close connections to the governor. That creates you know, a bad appearance, and what the appropriate response to that is, or legal implications are, I think is still subject to a lot of debate. But that's what my concern is, and I'm not quite sure how we can best address it.
Your Honor, this is Chris Caldwell. You may remember I actually appeared previously in your court and had the honor of appearing here in connection with scheduling Ms. Parento's deposition. And let me try and address that specific issue. I have a whole list of points I could make about why there is no ethics code violation here. And I think we've made most of those in our papers, in terms of including why we don't think that Anthem's reading of the FAC NDA is an appropriate reading. They're a third party and misreading what any of the parties meant. But let me try and address the appearance issue specifically.
Right.
And Your Honor,
because, you know, I mean, honestly, I will say, I think the ethics code, as it was in effect at the time of these events, I don't think the ethics code covered Ms. Parento. I don't think she would have been subject to it had she not, you know, signed an agreement with finance in which she voluntarily became subject to it. And the import of that is subject to debate. But I want to hear your.
Okay.
I
was gonna. You're making it tough for me not to explain or to address the import of that agreement, because none of the parties to that agreement have said that they thought they meant it, that it started the clock again, that it was anything other than a confidentiality agreement. If you look at exhibits 3, 4, 5, and 6 to Ms. Parento's declaration, and Your Honor, I understand there's been an avalanche of papers on the court with the court. But I really will hope the court would, we would ask the court to take the time to read Ms. Parento's declaration, the exhibits, and I know it's asking, but to address, because I think if you read that.
But that point is really that you all are saying that the NDA really had nothing to do with the conflict of interest. It was a confidentiality.
And that's exactly right. And there are 4 emails relating to it that all describe it as a confidentiality agreement, which without any question, she complied with. And I also would say, by the way, in the context of whether there was consideration for, if you wanted to make it involving the ethics code, if you look at the Creech case, this is not a Hornbook law situation. This is a situation where restrictive covenants on employment are disfavored, and there was not a benefit to Ms. Parento. There may have been a benefit to the transition team, but nothing fair, you know, that was a benefit to Ms. Parento.
No personal benefit.
The court's primary issue, which is, even, as the court expressly said, this is a subjective standard in terms of, and the court may view it one way, and particularly, I think, on the incomplete record, and what we think was actually a misleading record previously before the court, we could understand why the court may have had concerns. I actually think on the more complete record, it's crystal clear that there was no unfair advantage, no misuse of information. But just from the perspective, is a subjective appearance of impropriety a basis for disqualifying a bidder or overturning a contract? Kentucky law is crystal clear on that issue, Judge, and that's KRS 11A.104. There has to be a substantial influence. The misconduct, it has to be a proven violation, and it has to have substantially influenced the action by the state agency. And here,
There has to be some material, objective impact on the decision making.
That's correct, Your Honor. The decision, the language that one of the cases we cited is there has to be hard facts. It can't be a gut reaction, and there's good reason for that. The Kentucky Supreme Court in the Commonwealth versus Yamaha case talked about the reason for the Kentucky Model Procurement Act, and it was to establish uniform practices and procedures with objective measures. Because we're talking about commercial actors who need to be able to define their conduct with objective measures. And instead, the dangers of a subjective test are exactly what the Kentucky Supreme Court talked about in the Markham case, which it may make sense to have a subjective test in some contexts, but not in this context, where you need objective measures. And frankly, where all of the evidence on this point, and it's page 193 of Ms. Bates' deposition, was referred to by Mr. Kramer. Did the fact Ms. Parento was on the transitions team substantially influence the evaluation team's review of the 2020 proposals? Answer, no. Couldn't have been clearer, Your Honor. And so instead of hard facts, instead of actual evidence, Anthem is asking you to apply a subjective test that is not permitted by Kentucky law. And by the way, the prefatory language to KRS 11A.100 that says, in addition to other remedies provided by law, they haven't pointed to another remedy provided by law, Kentucky law, because once again, the statute is supposed to provide objective standards. And that's also consistent with the policy result of the Model Procurement Code and the Ethics Code, both of which talk about the fact they don't want to create unnecessary barriers to government service. Now, maybe you could rewrite the statutes, but serving for an unpaid transition team co-chair for 1 week, where you didn't gain any information of value to anyone, whether that should be grounds for disqualification for a full year. And by the way, the NDA agreement, even if you read it as making her subjective to the ethics code, it doesn't say which provisions. And she's definitely not an officer or a public official under the definitions. But the bottom line is, it's not the court. It would be a very dangerous road for the court to go down, and an improper legal road under Kentucky law to be applying a subjective standard rather than the objective test of proof with real evidence of a substantial evidence on the bid or substantial effect on the bid. The evidence here is not only is it ambiguous, it's directly to the contrary. There is no such evidence. All the available evidence proves the opposite, and there is no basis for disturbing Molina's contract because of any conduct by Ms. Parento.
Yeah, and I appreciate that argument. One of the reasons I'm still struggling with this is, I do as I've shared, I'd have a concern about the appearance here and the subjective appearance that one bidder may have had insider information or influence on the process. But, I will also candidly say that, based on my long experience in these cases and in state government in general, it may well be just as likely that that in the process, if someone has the appearance of influence with the governor, that the career employees who do the scoring may be as likely to hold it against them as it is to favor them. So the argument for a subjective or for an objective standard there, I think, does have some persuasive force, but it's again, I think it is unfortunate that we've got this to deal with. And I think maybe the legislature is addressing this in legislation now, which is probably where it ought to be addressed. But again, I appreciate your argument on that, Mr. Caldwell. And anything else from Molina?
Your Honor, if I could just sum up briefly. We did cite to you that Markham versus Corsoni case in which the Kentucky Supreme Court rejected the subjective appearance standard. We would rely on that. But to sum up our points, Judge, I know your time is limited this afternoon. First, we submit to you the Commonwealth correctly determined that Molina's membership was not subject to reassignment under the plain currently contracting language of the contract. And second, we've shown that Molina's contract is not subject to cancellation because there's no evidence of unfair prejudice or any improper influence in the procurement process. Finally, Judge, while we have shown in our brief, and I think we've highlighted today, why Molina is entitled to judgment as a matter of law on these points, the motions filed by Anthem, Humana, and United each involve issues of disputed fact that we've identified that require more discovery and that would preclude summary judgment in their favor at this time. Thank you, Your Honor, and I'm happy to answer any questions you might have.
Okay. Let me ask you, Mr. Kramer, how many members does Molina have now?
A little over 320,000. I think as of the numbers this morning, United was at 147,000. Anthem or Humana around 165,000 or so.
Okay. And how, Mr. Washburn, how many does Anthem have at this point?
Approximately 157,000.
Okay.
It's 157,000 and change. I'm not sure exactly
Yeah.
where that is.
Okay.
In your Honor, recognizing that we may not get to all the arguments, I do want to reserve the right to respond to Mr. Caldwell's argument, whether we
Sure.
do that now or at some other point. I'm happy to do it.
Yeah, that's fine. We'll keep plowing away, and I'll give everybody a chance to be heard here. So, but let's turn to Mr. Abate and Humana next.
Thank you, Your Honor. I appreciate that. Since Molina began with our issue, I appreciate a chance to respond. The question before the court on Humana's breach of contract motion for summary judgment is a contract interpretation which is subject to de novo review by this court. There's been a little disagreement about that in the briefs, but there is no deference due under a pure question of law that this court is interpreting. And we've cited the Kentucky Spirit case for that proposition. We think that it begins and ends with the plain language of the contract. And the most specific provision of the contract, which is the controlling one here, is in section 26.2, which says, if an MCO currently contracting with the managed care program does not continue with the managed care program, its membership shall be reassigned. Now, there are a couple of points about that as to what Molina argued today. It doesn't talk about current membership. It talks about currently contracting. The whole point of this provision, which is entitled Transition of MCOs, was to provide a one-time reallocation of the membership on 1/1/21 between the losing incumbents and all of the winning bidders under the formula set forth in 26.2. That was the clear purpose of it. The only parties currently contracting at the time the contracts were bid were the 5 incumbent MCOs. And in fact, even as Molina began administering a contract, it wasn't Molina's contract, it was Passport's contract. And as we've cited in our briefs, the statistics published by the Commonwealth continued to refer to those as Passport members all the way through the end of December 2020. So Passport was the contracting MCO up until its contract expired on December 31st. And as Your Honor pointed out in your question, Passport had no legal right to convey to Molina something it didn't possess, which was the right to retain members into 2021. I realized that Melina pointed to some slides where the word current is used in different ways in the contract that it submitted shortly before the hearing. I would just note none of those uses of the word current, which is a very common term and not a term of art, none of those are remotely similar to this context. And the Kentucky Supreme Court said in the Woods v. Commonwealth case at 142 Southwest 3rd 41, that although you generally presume a word when used in a statute multiple ways has the same meaning, the presumption is not rigid, and the meaning of the words may well vary to meet the purposes of the law. And same thing in the Sutton v. Shelter Mutual case, the Kentucky Court of Appeals at 971 Southwest 2nd 809 called it perfectly logical that terms may have a different meaning if used in different provisions of a contract. So the purpose of the court, even if the court found it ambiguous, would be, in the words of the Freer decision by the Supreme Court, to gather, if possible, the intention of the parties from the contract as a whole, considering the subject matter of the contract and the situation of the parties and the conditions under which the contract was written. If we rewound this a year ago, or even to last May, nobody, certainly not the Commonwealth, would have been arguing that the purpose of the transition of MCOs section was simply to set the stage for a private auction of membership between losing bidders and winning bidders to allow private parties to divide between them the membership of the state's Medicaid program. No one could have contemplated that. We also submit that the continuity concerns Melina has pointed to so heavily are really nothing more than a red herring. First, the Commonwealth went forward with the procurement knowing that it could result in the transition of members during a pandemic. Passport and Anthem at the time raised those concerns, and the Commonwealth went ahead nonetheless and refused to cancel the procurement. Second, Melina itself belittled these concerns when Passport raised them. We've quoted this in our brief. Although they've tried to walk those statements back, they're no less relevant here than they were at the time Melina made them. Those concerns are not about the language of the contract or the RFP, but political concerns that they're interjecting into this situation. Third, even if the court looks at continuity, the relevant lens is not who pays for the claim. The relevant lens is which provider is providing the care. And in our reply brief, we submitted material demonstrating that, in fact, Passport's network was significantly narrower than Humana's. There'll be very little disruption, even if the court were to consider continuity, which we don't think is a relevant consideration. And the number of people subject to an actual care management program by Passport was a fraction of 1% and could be dealt with appropriately if there was some concern about those members.
Explain that last point to me a little bit. Why would there not be a significant continuity of care issue if the court said all of the Passport members should be subject to reallocation?
Sure. Yes, a couple of points, Your Honor. First, again, that was the risk everybody was facing as we went into this procurement, as the court understands. That's the way the contract was written. But
yeah.
In Kentucky, in any willing provider state, providers are free to contract on reasonable terms with any managed care organization. It's not as if there's one network of Anthem members, or one network of providers, one network of Melina providers, one network of Humana providers. Providers participate with many different and sometimes all the MCOs. And from a patient perspective, what you care about is which doctor you go see, not whether Humana pays the claim or Passport pays the claim or Melina pays the claim. And we pointed to the evidence in the record from Melina's own documents showing the number of Passport members who were under a really acute active management program where it was being directed by the MCO as opposed to going to your own doctor and your doctor submits a bill to an MCO. Was very small. And if this court were concerned about it, we're talking, I believe it was fewer than 1,000 members in that kind of particular care management program. That could easily be addressed without violating the basic commitments the Commonwealth made to the other MCOs in the contract. And I will add, Melina, noted this morning, I think it has to be added that I think they suggested there was something like 140-some thousand members United has received so far. We pointed this out in our brief. That begs this question of the presumptive eligibility members. And I think it's clear, Your Honor, that there'll be two major hits to that number. One is this month, when eligibility will be lost based upon income and age verification requirements, and probably again later this summer, when the federal government's extensions on presumptive eligibility will expire. And we can expect over the course of this litigation a huge hit to this pool of members assigned to United, and that's going to ripple through all the other MCOs, because the plan the cabinet has proposed makes clear that assignment to the other MCOs of new members will be shut off until United gets to a sufficient threshold. And although the cabinet is representing that they already had 140,000 members, that's not a real number. That's a soft number. And who knows what it'll be when these PE members and members with too high of an income fall out. But we're all going to continue suffering under this for some period of time.
And back to the continuity of care issue, I guess, so your argument to some degree is that with regard to the patients who are covered, that there's a huge amount of overlap, I guess, between the providers, the primary care physicians and specialists who are members of the network for both Humana and for Passport.
And many other providers. We just dealt with the Passport and Humana. There are Venn diagrams in the exhibit to our reply brief that show the overlap, and you'll notice there's a significantly higher portion that's Humana only than that was Passport.
Yeah.
And the biggest amount is the overlapping circles in the middle. So, but Your Honor, I would say that as we come to the question of the merits, that to some extent goes perhaps to remedy. But as we come to the pure question of merits of was there a breach by the Commonwealth by the refusal to conduct the reallocation required by 26.2, there is still a damages remedy out there. Now, we think that the continuity of care concerns don't require refusing to enforce the terms of the contract. But even if there was some concern about that, that doesn't relieve the Commonwealth of its obligation to follow the commitments in the contract. So we haven't yet raised the question of appropriate remedies before this court. That's why it's only a partial summary judgment. But I don't think continuity should drive the merits analysis, because that can wait another day ultimately. Very briefly then, we've this may be my only chance. I won't dwell on it. I will just say we've raised this question of the second contract interpretation question of whether WellCare is eligible to participate in reallocation. We think that's another clear, plain language. It talked about 33% of total membership, which we think means statewide. We do disagree with WellCare on the question of exhaustion. We argued in our bid, in our dispute, that the membership had to be reallocated under section 26.2. This is part of 26.2, and so necessarily is subsumed within what we raised. But even if this court thought there was a question about exhaustion, futility would allow it to excuse any further exhaustion, where one, it seems clear the Commonwealth wouldn't even reach the question because they don't think any reallocation is required. And two, they have said in their briefing in this case, they do think WellCare is eligible to participate. So there's no question as to what their answer would be. And requiring another dispute would simply be a waste of the party's resources in this court's time. So.
Okay.
I've spoken enough. I think I'm going to stop unless the court has further questions, but we appreciate your
Okay.
attention.
All right. Thank you, Mr. Abate. Well, I think maybe at this point it would be a good time to go ahead and hear. Well, let me hear. WellCare was kind of dropped in there. Let's go ahead and move to WellCare. Okay.
Thank you, Your Honor. Steve Neely for WellCare, and I'm joined with my co-counsel Sarah Charles Wright and Brian Wagner. To address briefly the point with respect to WellCare from Mr. Abate's argument, it is certainly I want to address their argument that WellCare is not entitled to participate in any reallocation of membership should the court decide that the Passport membership should be reassigned. With respect to our argument regarding exhaustion, we understand Humana's argument with respect to their claims to CHFS and the finance cabinet were regarding membership, and that should be sufficient to cover their argument, and there's no futility to send it back. We're not necessarily arguing that the court needs to send that particular claim back to the cabinet. What we are arguing is that that claim is inappropriate for summary judgment at this time. And the reason is what's outlined in our brief, which is there is a factual dispute with respect to the total MCO membership language in section 26.2. Humana's argument is that total MCO membership can mean nothing more than statewide membership. And as we cite in our brief and explain in detail, total MCO membership refers to the types of MCO membership. And in fact, MCO membership has always been allocated by region in the Commonwealth since the inception of the MCO program in 2011. That's in the affidavit from Bill Jones at WellCare addressing the regional membership. And it's in the old version of section 26.2, which was attached to the RFP. So we do think that the language in the contract is at best ambiguous. The contract does not say statewide membership, and we don't think it's appropriate to enter summary judgment in Humana's favor on that issue. We do, however, join Humana's motion with respect to the passport membership being reassigned. We think the clear reading of 26.2 is that the passport membership does have to be reassigned. And with respect to Melina's argument about, and the Commonwealth's argument with respect to the currently contracting language, our argument, Your Honor, is when you look at that currently contracting language, the plain meaning of currently contracting is at the present time. And that draft contract was included with the RFP. And so we would urge the court to read that language the way the bidders did in May 2020, when they were putting together their proposals and new MCOs are coming into the market, trying to understand the viability of entering into a tough MCO market. And they say, well, how am I going to get members? You read 26.2 and they see, well, if one member is not chosen for award, that membership will be reassigned. And that's what that means. Melina at that time.
I understand the persuasive force of the argument that that provision would be kind of rendered meaningless if the losing bidders could sell their assets and their membership to a winning bidder and thus keep those members out of the reassignment pool. And should that be a private auction or a public reallocation is one of the issues there. So.
That's correct, Your Honor. And that is a concern because we do have the open enrollment period. And the entire reason for the RFP was for the state to be able to assess the MCO providers and make sure that the MCO providers who are selected have the networks that provide the care and the continuity that the state is ultimately concerned about. Facilitating a sale process the way the current setup is, I would suggest, not consistent with the purposes of the MCO network and the RFP in general. So we join Humana's motion with respect to the passport membership. We obviously oppose it with respect to the attempt to exclude WellCare. And then, Your Honor, WellCare also opposed Anthem's motion for summary judgment on two issues. And so I'll just briefly touch on those, knowing that time is short. With respect to Anthem's motion, the two issues we opposed on was the evaluation issues. We understand Your Honor's October preliminary injunction ruling, but when we look at the evaluation performed by the cabinet, the three main arguments that Anthem proposes, we think they have not met their burden here. Their three evaluation errors are with respect to oral presentations not being conducted. And the evidence before Your Honor shows the RFP language was clear that those presentations would not be required. The Commonwealth reserved the right not to hold them if they wouldn't affect final rankings. And everyone who testified said they did not believe the presentations would affect final rankings. Secondly, with respect to the sections where scoring was waived, Anthem's argument on those sections is premised upon its assertion that if the sections had been scored, they would have been evaluated qualitatively and they would have scored higher. But the testimony from the scoring team shows the exact opposite. The sections actually require that the offerors just provide a statement regarding litigation history and PHI breaches. And the scoring team viewed that just as disclosure requirement. There's nothing saying they were going to evaluate the actual litigation history or PHI breaches from a qualitative standpoint. It's just, did you provide the information or not? And when they found the discrepancy in the instructions, they decided the fairest way was to award full points. But even if the instructions were clear, there's nothing in the record to support Anthem's assertion that it would have scored higher.
It would have helped that. Yes.
I'm sorry, Your
Okay.
Honor.
You're saying that there's nothing that would demonstrate that would have helped them.
That's correct, Your Honor, because they viewed it just as disclosure. Did you give me the information or not? Not where they weren't evaluating the quality. And then the last evaluation error that Anthem cites is the deduction of points for its certificate of authority. The evidence in the record suggests that Anthem's electronic copies of its proposal did not have a certificate of authority, but its hard copy proposal did. And Anthem argues that the RFP language saying its hard copy governs over the electronic copy means it could not have received a deduction in points on that basis. But Anthem's argument goes too far because their point deduction is for not following the RFP instructions, which required identical copies of their proposals in both electronic and hard copy. And the hard copy did govern. That's why Anthem was not excluded for not providing a certificate of authority. But it doesn't mean that deducting points is improper if an offeror doesn't comply with the RFP instructions. So we think that the evidence in the record does support the judge, Your Honor, finding that the evaluation was proper and reasonable, and that the preliminary injunction, although we understand why it was entered and the court's concerns at that time, a full reviewing of all these facts show that Anthem's evaluation errors are not, in fact, errors. And finally, Your Honor, we opposed Anthem's motion also with respect to issue number 4 in their brief, which is 5 versus 6 MCO awards. In our view, when you look at the RFP language, the RFP says the Commonwealth was seeking up to 5 awards. And there's no language in the RFP that would allow more than 5 awards. There's no discretion for that. We are aware, and we cite cases in our brief for Your Honor, particularly in federal procurement context where additional awards are made. But the RFP in that language is more open to additional awards than it is here. So I understand we're on tight time frame. I'll stop there. Happy to answer any questions.
Okay. All right. That's very helpful, Mr. Neely, but let's go ahead in the interest of time and let's move on to Aetna. Is Mr. Keith on or?
Yes, Your Honor. Mr. Kessler's on as well.
Okay. All right. And Mr. Kessler.
Yes, Your Honor. Brian, if it's all right, I'll just take a.
Please, handing the mic to you.
Okay.
Your Honor,
All right, Mr. Kessler.
Thank you for the opportunity to be heard on this. As you surmised when you reviewed the motions, none of the various motions are directed against Aetna, nor did they assert that Aetna's award of a contract is inappropriate or should be reconsidered. So accordingly, in response to the motions, we have merely supported the Commonwealth's implementation of managed care and certainly this court's decisions and have honored the same. So as a result, Your Honor, we would stand by the briefing that we submitted and happy to answer any questions that the court may have for clarification's sake.
What is Aetna's membership under the MCO contract now?
Currently, Your Honor, it's 241,000, just over.
Okay. All right. Well, and I know if I've got any additional questions on Aetna, we'll come back to those, but let's go ahead and move on to United. Ms. Barnaby, are you on deck here?
I am today. Thank you, Your
Okay.
Honor. First, I want to note, because we were talking about current membership, yes, the numbers look like United has 147,000 members as of today, but as we have all become very aware, that's about 142,000 are presumptive eligible that are disappearing and can be disappearing at any day because of those eligibility requirements.
Yeah.
So I think as the last, MCO speaking today, we're coming forward with what I would think is the most threshold clear of legal issues to put before you, which is what you asked us to address in this briefing. And that is a clear question of plain and unambiguous contract language. Does the contract provide for contracting with any more than 5 MCOs? And as multiple parties have said today and in their briefing, as the Court of Appeals has recognized, as CHFS has stated, the contract provides for only 5 MCOs. It says that CHFS was seeking up to 5 vendors to provide a managed care organization program. I don't think that we need to spend a lot of time harping on that language because I think 5 is 5. My 4.5-year-old gets what 5 is. So I think all of us here today get what 5 is. The arguments that have been raised are essentially arguments about whether this language is material to the contract or for some reason whether it can be ignored. And we submit to you, Your Honor, that as an initial matter of contract interpretation, that does not affect what the contract says, but the language is material and also it should not be ignored. So as to the language being material, I think, one, it's easy to reject this argument that a provision has to appear more than once in a contract to somehow make it more material. We know that this term is material by the fact that it was put in there for the purpose of enticing new MCOs to participate in this market that was highly competitive. We see it as an underlying premise for the 26.2 allocation, that there be an assumption that you would have a potential change of MCOs that you would need to address. And there's also the testimony in the record from United that it was, in fact, part of its express understanding that there would be no more than 5 MCOs. Now, on to the point of whether this language can, for some reason, just be ignored. We strongly believe that there is no basis for doing so. The court, as seen in the Laster case and Guardian Angel and Bell, is not authorized to affirmatively award contracts in this context of procurement disagreements. That litigation, the litigation result should not be an affirmative award or addition of a contract. So what we're talking about here would be some modification to the language of the contract, and changes and modifications of the contract must be made by mutual agreement of the parties. And as you've heard today from multiple MCOs, there is not an agreement to amend that language. So there's no basis for amending that language outside of the contract procedures. That's not, that is the procurement responsibility and contract language, negotiation of the contracts, that is a responsibility of the executive, and that continues to lie with them. So we think that this language is clear, it's unambiguous, everyone's in agreement, and this is the most threshold of questions that is an easy one for the court to rule on. Now, there have been other issues raised in other briefing as to United. I will not give full argument on that, recognizing the time, but I think that it's very clear that there's no basis for ruling and dismissal of United's cross-claim at this point on breach of contract, not least of which is because the CHFS cannot raise the defense of impracticability or impossibility because they have not affirmatively challenged the court's order. On Anthem's arguments regarding Ms. Easley, they've presented no evidence, put forward no evidence contradicting the information put forward by United. The pointing to some statements in written discovery from CHFS are not as explicit and clear-cut as has been raised. In fact, much of that response was based and qualified on CHFS's current knowledge, admitting that Ms. Easley is no longer employed at CHFS, and so they do not have the access to Ms. Easley's brain and her response. And there we have this issue of, if you are concerned about the appearance of impropriety, we have actual testimony of improper behavior where Ms. Easley, who is an executive assistant to the secretary, so had access to more information than just this 1115 waiver, was stating and publicly talking about to others how she used that information to participate in the response. I will not, recognizing the time, I want to give the Commonwealth time to respond, I'll also say simply that on Anthem's arguments regarding scoring, I think WellCare touched many of those points. The oral, I'll note also though on the oral discussions, it was provided for in the RFP that orals were not required. And when you harmonize together KRS 48A.0857C with the regulation 200 KAR 5307 section 5.1, that when you read those in harmony, the fact that the finance cabinet knew this area so well, that the managed care contracts had been in existence since 2011, it's a highly competitive market. The statement within the RFP that oral presentations and then also in the response to questions that oral presentations not be required makes it not necessary that oral presentations occur. Even if there were some protestable ground on that, Anthem failed to raise it at the proper time in response to the RFP itself, and therefore it's untimely. There's much more I could say, but I will stop at that point.
Your all's overriding position, though, is that the contract can't be implemented with 6 instead of 5, and that the membership that Anthem should be disqualified, and that the passport members, so all of the Anthem and the passport members should be reallocated. Is that?
Well, so I'll say, break it down that there should only be 5 contracts, not 6. Anthem should be disqualified and therefore not given any membership. And then separately, we agree Molina should be disqualified. And because of that, its membership would be reallocated. We have not signed on to Humana's separate argument.
Okay. All right. Well, let me hear from Mr. Duke.
Thank you, Your Honor. That's a lot to kind of get through. First of all,
Yeah.
I can provide the court, and I have periodically provided all the parties with the weekly updated list of the MCO enrollment. So I'll send that to the clerk.
Yeah, I would like to see that.
Be a little easier to see it in a form than it's taken on the note. So, not to go over ground that's already been plowed and to try to use my time as wisely as possible here. I want to go first address the issue of 26.2 and the position that the Commonwealth has taken from the beginning of this litigation in regard to how Molina was treated and how they were viewed as an incumbent. It is our position, and I think it's fairly extensively briefed, but just to reiterate, is that on September 1st, when the assignment was complete, that Molina stood in the shoes of Passport. It was the asset purchase agreement was finalized. The assignment was finalized by CHFS, Finance, and DOI, Department of Insurance. And at that time, when that was all complete, that Passport ceased to be, and Molina stood in their shoes with all their assets, including all of their membership. And it is our position that I think Ms. Barnaby said this is a letter of this is an issue of contract interpretation, and the letter of and reading the contract. And it's our reading that the clear meaning means that at that moment, Molina, by virtue of that assignment and purchase, became a incumbent MCO and was entitled to keep their.
There was no more Passport at that point, and Molina enrolled all the members who had been enrolled in Passport.
That's correct, Your Honor. Yes, at that moment, they stepped into their shoes with all their assets. And like I said, for all intents and purposes, the Passport ceased to be, and Molina took over everything. And that happened obviously in September 1 of 2020, well before the new contract periods began on January 1st of 2021. We have also moved for judgment in regard to a number of things. First of all, in regard to United's cross claim. And I know that some of these issues have been dealt with, but I'm gonna try to hit them again briefly.
Yeah, go ahead, please.
I think I've pretty clearly stated what we feel about Molina and how they were treated. That's on our briefs. There's no need to state that again. It is also our position that we have met our obligations under the 2021 contract to Anthem. Now, I realize that it's been said twice here about the presumptive eligibility population, that it is fluid, and that is correct. But however, at this time, almost 140,000 people are members of United. They are very real. I think someone, I can't remember who said that they may not be real. They are very real. The capitation payments that are being paid are very real, and that they are in fact the membership. Now, there are some issues that are coming up in regard to the PE population that will affect that age and eligibility, and that's coming up in the future. And we admit that. But at this moment, it's our position that we have not breached and we have met our obligations under the current contract to United. And furthermore, to Mrs. Barnaby's point, that we cannot claim that impossibility, I think is the term, about because we did not seek interlocutory relief of the court's preliminary injunction. I don't think that's true. What we did is we replied to the Court of Appeals. We reserved all of our rights there. We made a calculated decision here that at that time we had a mandated CMS open enrollment period that we went to them and asked to push back, and they would not give us permission, and that it behooved us and the population to carry on with the open enrollment period. I know the term continuity of care has been used a lot here today and throughout this litigation. It's always been important to us because it's mandated by our federal partners to consider continuity of care. And that's just one example of where we had to do that. And that was the decision that we made. We agree in regard to Anthem and the relief that they're requesting. I think our position has been very well briefed. We rely on the decision in the Guardian Angel case that has been referenced here by I think multiple parties that pursue. Well, one, we don't think that there's any issues with the bid process. I think our friends at WellCare did a very nice job, kind of outlining why we think why they think that the bid process, the scoring process, was correct. All of our positions there are laid out in our brief in regard to the oral argument. the oral presentation and the other issues there. I think we briefed them well, but we think that was a good. That the scoring process was proper and that the team did their job. I think the role of Emily Parento in all this has been argued and briefed. I don't need to go there. I think that's properly before the court, and then the court has all the evidence that is there. Finally, and let's see, I want to get to our position in regard to Humana's breach of contract claim. Once again, I'll reiterate our position as to Molina. They were treated as an incumbent, and I think I've stated why. Also, that's also in our brief. We also, I think that something else here that in regard to the claims of Humana and our claims of breach, as an incumbent MCO, when the bid process started, be it the 2019 RFP or the 2020 RFP, it's our position that the expectation of any incumbent going forward, the only realistic expectation they have is to retain their existing population. And I think the contract's very clear in that. That is the only expectation that they should realistically have. This position of multiple parties that because there could be a new MCO and that would lead to a reassignment of members, that's a possibility, but there's also a possibility that all incumbents win as well. So that's an unrealistic expectation.
That's not a property right.
No, it is not. It is not. And I think the contract was very clear about that, about what an incumbent MCO should expect going forward. So just to summarize, as far as our position, we think that the RFP process was good. We support the decision of the Finance and Administration Cabinet as to the underlying appeal, and the decision in regard to Anthem. I believe all our other positions are set out in the briefs, and I'll be happy to take any questions.
Let me ask you, Mr. Duke, because one of the troubling things to me about this case is that there are just some issues where I think there's no real clear answer. There is I think to some degree that there's a cloud over this procurement for a couple of reasons. One is the application of the executive branch ethics code to the bid process and to Ms. Parento. Another is this the scoring. What I have initially ruled is problems with the scoring in terms of arbitrary action, and that may or may not turn out to be the case after we completely adjudicate all these issues, but still some unusual issues with regard to how the process worked and the scoring went. And of course, that raises the issue because of my ruling, which, I kind of created this problem. But this issue of the contracts requirement that, or at least the contracts provisions about having 5 bidders, and then under the court's ruling, we've got 6 at this point. So, I am concerned about, number one, how does the cabinet feel about the way the MCO contract is being implemented with the 6 instead of the 5? And what would be the impact if the court were to rule that this is kind of a situation which can't really effectively be untangled, and because of the cloud that is over the process at this point, that the best thing to do would be to set aside the award and to go back to square one and to rebid the contract. What's the cabinet's view about that as an alternative?
As to the first question, Judge, I think you've picked up on it. Right now with 6 is it's a very hard thing to do. We're having to use the presumptive eligibility population to, as I said, fulfill our contractual obligations. That there's issues there. There's issues there with eligibility, obviously the public health emergency, and so that's not I think I can, just to be completely candid with the court, I don't know if that is a long-term solution, if that can continue. I mean, it's working right now. So I think that's the answer to your first question. I think the answer to the second question is really in our brief that we stated. And I think the law is pretty clear that there's 2 choices here: either that the contract award and issue was in total compliance with the model procurement code, and Anthem loses their appeal. That's option number 1. But if there is a finding that the contract award violated the model procurement code, that leaves the only outcome is to be a rebid. And I think we're cognizant of that.
Yeah. Okay. All right. That's very helpful, Mr. Duke. And I guess let me ask Mr. Thomas if there's anything he wants to add on behalf of the finance cabinet. I know they've been working in tandem with Mr. Duke, but if they've got anything additional, I'll be happy to hear that.
Thank you, Your Honor. Very briefly, I think Mr. Duke laid out at least the County for Health and Family Services position very well. If this court decides that the procurement was flawed to a degree that a rebid would be required, of course, both Finance and Administration Cabinet and the Cabinet for Health and Family Services would need time to do so, and so. Obviously, this procurement process, and Commonwealth's gone through 2 of them so far, is pretty complicated. And so, we would probably need, sufficient time to think about, how long the process would take and this and that. And of course, given this litigation, the RFP may change, the number of bidders may change. All cards go on the table once the contract needs to be rebid. We've heard a lot of arguments today. I would echo the comments of WellCare and United in terms of their comments regarding the procurement process and the oral presentations. the two categories where bidders were awarded full points, and again, the deduction of points from Anthem that that resulted from their failure to provide their certificate of authority in their electronic bid. Those matters have been fully briefed, I believe, but we would like to reiterate them because at its core, this litigation is a challenge to the Secretary's determination following a protest of a procurement
Process.
award.
Yeah.
So we believe that that award was not arbitrary, was not capricious, and was not contrary to law, and thus should be upheld. But again, if the court finds otherwise, certainly we'll take up the torch and rebid this contract.
Okay. All right. Thank you,
Your
Mr.
Honor,
Khan.
I'm sorry to jump in for just a second, but as the
That's
only
okay.
party coming to this without an incumbent membership, I do have to implore upon you how a rebid would affect United, and that that does have a particularly unique impact on us. And as CHFS has named, that the PE solution, to the extent is even a solution, and we have feelings about that, is short term, and as the cabinet has stated, a rebid would be long term, and so United would be continued to be harmed. So, if there is a cloud over this, it seems to be related to Molina, and canceling Molina's contract could resolve that. But really, I just want to remind you of the impact that a rebid would have on United.
Okay. Well, let's do a lightning round here to let everybody get a last word in, because I know there've been a lot of issues raised that are maybe unique to each party. So let's do a lightning round of responses or replies, and we'll start with Mr. Washburn.
Thank you, Your Honor. I will do my best to address these issues. First, with respect to the objective standard and the concerns that the court has expressed as to Ms. Parento's participation, that's contemplated by the Code of Ethics and the 1 year cooling off period between the time that she served and the time that she's permitted to go forward. The concern of an appearance of impropriety is built into the Code of Ethics with respect to having that postponed by a year. So,
your argument is that that's an objective criteria right there. So
absolutely, Your Honor, and I think the court's concern is reflected. The court's concern, well, it looks bad. It does look bad. That's why the Code of Ethics was written, to permit that year cooling off period. I'll also note that the evidence does establish that Mr. Friedlander, who is now the Secretary of CHFS and who participated with Ms. Parento on the transition team in advising Governor Beshear, changed the scoring team. He overruled Commissioner Lee with respect to who would score the 2020 RFP. So the suggestion that there's no evidence of any kind of impropriety in the scoring is belied by the record. We pointed that out in our briefs back in the fall, and it's clear evidence. I do want to note we'll stand on our points with respect to the scoring issues. We continue to assert that those were violated, and contrary to the KMPC and to the RFP, that we raised those appropriately, notwithstanding WellCare's arguments. I will note, no one filed a motion for judgment on Anthem's claims other than Anthem. So to the extent that the court denies Anthem's claims, we would ask that we be permitted to conduct discovery so that we can move forward with those claims. Also note that we did not move with respect to the additional scoring issues that we had identified, because we do think that there are questions of fact as to those. So if the court is inclined to reverse itself with respect to the three issues we've raised, there are additional issues that the FAC failed to address in our protest that would persist. United raised the argument about that any modification to the agreement must be made by mutual agreement. That's true, but CHFS has the authority to cancel or to terminate the contract for convenience at any time, and the court certainly has the authority to cancel the contract, as we've discussed today. And I'll make one additional point, again, with respect to the orals. United has argued that you can harmonize the regulation with the statute. The statute trumps the regulation, and the statute expressly contemplates that oral presentations will be conducted unless the terms of the exception can be met, the statutory exception can be met. That exception could not be met. In fact, the scoring team and the FAC paid no attention to that statutory requirement. Oral presentations were required by statute and the RFP, and they firmly disregarded it. With respect to all other points, Your Honor, and in light of the lightning round, I'll stop there. Thank you.
Okay. All right, Mr. Kramer.
Thank you, Your Honor. Just a few points to make. First, I do need to clarify an important point here, and that is Passport did not conduct a private auction. The time frame of this transaction we described in our pleadings, our briefs. Molina announced the purchase in July of 20. There were multiple levels of regulatory review and approval, both state and federal. The assignment of the Passport contract occurred at the end of August, closed effective September 1. And at that time, Molina stepped into Passport's shoes and was a currently contracting MCO with the Commonwealth from September through December. It received all of the rights under the Passport contract. Passport had no right to assign future right to members to Molina. It was the cabinet, Your Honor. It was the public action, a public reallocation that, as stated in the 2021 contracts, determined that Molina was currently contracting and that in the interest of continuity of care and under the contract, those members would stay with Molina. So it was not a public auction. It was a private reallocation of members by the cabinet. As to Mr. Washburn's argument about the ethics code and the one-year ban, Your Honor, that only applies first if she was subject to.
We don't need to go into that anymore.
Right. You sound like you acknowledge that she wasn't. The General Assembly is working on that. But it would only preclude her work on things she was directly involved in, and there would have to have been a substantial influence on the procurement. None of those are true. Just briefly, Your Honor, on Humana's argument about overlap in provider networks, their Venn diagrams do have some overlap, but they're not 100% coextensive. And those Venn diagrams were only for hospitals and specialists. They did not include primary care providers. So even under their diagrammatic submission, there would be some jeopardy to patient-provider relationships and a risk to continuity of care. Your Honor, they suggested that you should micromanage the contract by assigning 800 members who are providing care manager services. Really, that's more of an issue for the auto assignment algorithm and not the currently contracting aspect. But in any event, where exactly does the contract allow that sort of ad hoc piecemeal adjustment? And Humana apparently wants you to micromanage the Medicaid program in that respect. We don't think that's advisable or appropriate. But to their specific point about only 800 members, Judge, if you look at Stephanie Stone's affidavit, that showed that even though the number of enrollees under active case management at any one time is relatively small, that those teams work with a significant portion of the enrollment over the course of a year. I think the number was 6,500 who need case management services in general. And what we're saying is that those thousands of people that Molina now has institutional knowledge about, personal relationships with, it's a significant portion of the enrollee base.
Yes. Okay. All right. Anything else?
Just one more point, Your Honor. As for a rebid, it certainly shouldn't be ordered because of any involvement of Emily Parento in this procurement.
Okay. All right, Mr. Abate.
Yes, Your Honor. I'll be very brief. First, Mr. Duke said that the only realistic expectation any MCO had was to keep their own members. That's not quite right because the way they wrote the contract. We wouldn't be here claiming we were entitled to more members if the same 5 MCOs won. The point is there were 2 departing MCOs. Under the rules set forth by the Commonwealth in the contract, those members should have been reallocated. That's simply our claim, that under the rule of law, we are entitled to enforce the contracts we have executed with the state. Secondly, I just have to reiterate, when Molina did an asset purchase of certain assets of Passport, it did not become Passport. Passport didn't cease to exist. Molina was assigned the remaining administration of Passport's contract for a few months. This does not allow them to claim a right that neither Molina nor Passport possessed at the time, but that is precisely the import of the legal argument if the court were to accept it. I
So
will note
your argument is that an asset purchase doesn't include the people. It didn't include the enrollees, right?
And to that point, look at the structure of the deal. It's been widely reported there was 2/3 of the purchase price was a performance fee depending upon how many of those enrollees stayed. So it was not baked into the deal. They couldn't sell the members. The cabinet had to assign them, but we submit it was contrary to law for the cabinet to allow them to keep members that everybody understood at the time of the bid were to be reallocated from a losing MCO.
Well, I guess, we did have an open enrollment period and they could have enrolled in Passport if.
No question. We don't quarrel with that, and we're not suggesting for a second that this would override member choice. That's never been our argument. But the point is, unfortunately, auto assignment runs the choice for the vast majority of members.
Correct. Yeah. Okay.
And then the last point, Your Honor, we're not asking you to micromanage the Medicaid program. We're simply asking that the contracts be enforced as written according to the rule of law. And we do oppose, however, a rebid in light of the fact that it would be a huge and significant burden on everyone, not only the MCOs, but on members. It would create substantial confusion. I neglected to say this, and I won't reiterate the points for it, but we do support Anthem's request in our brief that the correct solution would be to disqualify Molina because there was more than an appearance of favoritism in light of the issues we've just been discussing. So I would reiterate, for the reasons stated in our brief, that would be our preferred solution rather than a rebid.
Okay.
Thank you, Your Honor.
All right. Mr. Neely.
Nothing further from WellCare, Your Honor. Thank you.
Okay. And Ms. Barnaby.
I want to remind the court that this is an appeal of the agency decision. And so as to Anthem's claims, we can get to a final judgment based on the protest decision and the record. We hear again, Anthem seeking to delay because every day of delay is a benefit to them as an original losing bidder. Molina contract should be canceled because of at least the appearance of impropriety. Anthem should be disqualified because of actual impropriety leading to the false attestation due to their employment of Ms. Easley. She didn't take a year off, cooling off period. She had access to confidential information, and Anthem has put forward no information to say that that wasn't incorporated into the virtually identical RFP process from 2019 to 2020. To the extent there is any cloud over Aetna, WellCare, Humana, and United's awards here, it could only be from the oral presentations. And as we've explained, Anthem is wrong on that point. The statute does not contradict the regulation and so therefore does not trump it. The regulation provides a means by which it can be documented that the oral presentations are not required. And I'll close with what I think I hear agreement on actually from this hearing is that we should not continue with 6 MCOs, perhaps only Anthem and maybe Molina, not fully in agreement. But it sounds like we've come to the conclusion that the contract says 5.
Yeah. Let me ask you, Ms. Barnaby, again, to make sure I understand what United's concerns would be about rebidding the contract.
So the concern with rebidding the contract is that if you rebid the contract, you can't just stop providing services tomorrow to all of the enrollees. And so the parties would be continuing to provide services, and United remains in the position that they're in now, which is that as a 2-time winner, they have the worst position in terms of membership that has been provided, and that there are a losing bidder, and then obviously we have the Passport Molina issue, which is separate.
Yeah.
That they're benefiting. And so United,
your marginal disadvantage, it would be locked in at least through the through the rebid process.
Right, and otherwise bidders that should be disqualified for the reasons the
Would
court
be
has
benefited.
noted continue to be benefited.
Yeah. Okay, all right, fair enough. Okay, well, this has been very.
Your Honor, if I
For the
if I may
court.
just briefly, it
Yes.
is Mark Kessler on behalf of Aetna. I'll be very brief, and I genuinely appreciate it, but I do want to be heard on this very important issue of rebidding because
Yes, uh-huh.
I
Happy to
think
hear you on that.
the one thing that the court has not heard about is the detriment to the beneficiaries in that case. And Ms. Barnaby was addressing it tangentially, but I want to make sure that you're aware of it head on. And that's this is the main reason that the Commonwealth undertook the opportunity to continue managed care and then to tweak it in this 2020 application for the RFP is to make it better. And the statistics and the background and the research and the Commonwealth itself will tell you that it does. And so any delay in the process takes it away from those beneficiaries who deserve to have that managed care and those better life outcomes.
That's,
And-
you're referencing the provisions of the contract that broaden the scope of care and provide
Correct.
additional benefits to the Medicaid population.
100%. And there's one aspect that this court cannot lose sight of, and that's the SKY program. The SKY programs did not exist before this implementation. And we went through this process, and as you heard, nobody has indicated that the contract should be taken away from Aetna. And in this particular circumstance, it won the SKY membership, which is just over 27,000 children. And so the problem with taking that back and redistributing or stopping that program is that the beneficiaries of the SKY program are the ones who are going to be hurt, because typically, and the statistics bear out, that once you change those providers, they never ultimately all come back. And then we are losing care and provisions to those children who need it most. So as you're evaluating the decision as to whether or not to be a rebid, I'm sorry, Your Honor.
No, that's helpful. Can you help me with the what is the SKY program?
Sure. The SKY program, and Ryan could give you even more detail, but the SKY program was allocated, that was started this upcoming contract, and it was provided for the children who are receiving Medicare benefits as a result of their low income status as well as their health status. So absent this program, they don't receive those benefits. And that's the problem, Your Honor. And therefore, we would respectfully ask the court to consider that if you are going to rebid, that the SKY program be outside of that rebidding process, because of the implementation of it and the complication that there would be and the detriment to those beneficiaries.
Okay. All right. Well, again, that's.
Your Honor, Your Honor, I'm sorry, this is Wesley Duke. Can I say one thing?
Yes, certainly.
I apologize. And I'm prepared, and actually I was just going to stand on our briefs. I think they speak for themselves, but I feel compelled to do this. Going back to Mr. Washburn, he misrepresented to the court. Secretary Friedlander never changed the scoring team. The scoring team was the same for both of these RFPs. There was some confusion in some email, I think, went around, but he ultimately came in and corrected it to have the same team on both RFPs. I'll submit an affidavit if the court would want one.
Okay.
Your Honor, Ms. Bates testified that the scoring team was to change. Mr. Friedlander called Ms. Bates into his office, just the two of them, and he said, and Ms. Lee operated under the assumption that there would be a separate scoring team for the second RFP. He called Ms. Bates into the office and said, it's going to be the same. That's the testimony of Ms. Bates.
Okay. Well, I'll let Mr. Duke clarify that if he wants to.
No.
And I guess I'm just going from memory, but I was not really clear that Commissioner Lee was even appointed during part of this process. I kind of thought her appointment kind of came later on, but
I think she came on, Your Honor, I think she came on board on January 16th, I believe. maybe
Okay, well, that's
somewhere around-
earlier, that's earlier maybe than what I thought, so.
So, but I'm just wanting to clarify. I thought the comment was
Yeah.
that the team was changed. The team was not changed. This was the same scoring team.
There was a discussion of it, though. Okay. All right. Well, again, all of this has been very helpful to me. There's a lot of issues for the court to plow through, and I'm going to do my best to get you all the court's take on all of these issues. And I'll try to do it promptly because I know time is of the essence, and your arguments and have been very helpful, and the briefing has been very helpful. And again, I appreciate it. And I'm going to go ahead and recess at this time with, again, with the thanks of the court for the excellent arguments and presentations. So with that, the court will stand in recess.
Thank you, Your Honor.
Your
Thank
Honor.
you, Your Honor.